Hey, everybody. Thanks for tuning in. I'm Anjanette Levy. And again, thanks for tuning in. Please like and subscribe, share this video. We're going to be talking tonight about Vallow Daybell, who's on trial in Maricopa County, Arizona, for the conspiracy to murder her estranged husband, Charles Vallow, all the way back in July of 2019. And joining me to talk about this is somebody who is no stranger at all to high profile cases. He is Kirk Nurmi, and he actually represented years ago Jodi Arias. So Kirk, thanks so much for coming on. It's been a long time since we've been able to chat. Your thoughts, first off, on Vallow Daybell representing herself.
Hi, Anjanette. Yeah, it has been a while, and it's great to catch up and talk a little bit about talk some true crime. It's been
Yeah.
too long since we've done that, but yeah, Lori Vallow's choice to represent herself in some ways doesn't surprise me. I mean, we've seen her want to capture the spotlight, and she's done some local news interviews, and of course, people might remember a couple of weeks ago she did an interview with Dateline. So obviously she likes that attention. She has some sort of agenda that she wants to get out in the world that I feel like, or she feels like her attorneys can't put out there. What that is, we're in the day 1.5 of trial. We don't know exactly what that is yet or why she made that choice. There's various reasons why defendants go represent themselves. And we can talk about that if you want, but I certainly think Lori has some sort of agenda behind her choice.
Yeah, I'm wondering why. I mean, obviously she feels she's her own best advocate. I mean, she could have repped herself, I'm assuming, if she had chosen to do so in Idaho, right? I mean, I don't know the intricacies of that in Idaho, but she could have and she didn't. And she
Yeah, I mean it's
here.
a universal Sixth Amendment right. Now there might be some difference in case law, like if a person decides to represent themselves and bounces back and forth. There's some differences in that, but ultimately any defendant across the nation can make the choice to represent themselves. It's never a good choice, but it's a choice that can be made. And you're right, Anjanette. She probably feels that she's her best advocate because I'm sure the attorneys that she's had along the way, particularly the ones that she dismissed, were probably telling her that she's probably going to be found guilty or didn't believe in her innocence. And that can be one of those reasons, like she believes in her innocence and what have you. And so she is going to represent herself because, as you put it, she's her own best advocate in her mind.
What's that like? I mean, what's that like with a client? I mean, take me behind the scenes, obviously, without violating, attorney-client privilege or, what's that like? Do you ever like sit down with a client when they're in a really bad situation, like charged with something like murder, the most serious crime that you can face in our criminal justice system? And you just sit there and do you just, even if your client's like, yeah, I didn't do this or I'm innocent, do you just sit down and say, look, like the evidence is there, they are going to convict you? Or do you say like, I think that you're going to be convicted? Or like, how do you have that conversation? I'm sure you tailor it to each client because you're supposed to be getting the best result for them.
Right. I think my approach, and probably every attorney might have a different approach. My approach was that I was not there to be my client's friend. I'm not there to sugarcoat anything, say, okay, yeah, we'll go to trial. I can say, look, here's the evidence, and here's what I think is likely to happen to you at trial, as opposed to what would happen if you, say, took a plea agreement. And that's really only the most germane discussion when you're talking about going to trial versus plea, right? And you say, this is what could happen at trial, and this is what would happen under the plea agreement. And if I felt like they were absolutely going to be convicted at trial, I would tell them that because that's fair. That's the choice they have to make. They have to live with the consequences. It's not my decision, but they need to know the facts in order to make that decision. That was always my approach.
Right. Is there anything, and I know representing Jodi Arias had to be difficult, to say the least. And I don't know Lori Vallow. I just know what I've seen on body camera and heard on jail calls and what I've witnessed in court. Um, Is there anything that you're seeing that kind of reminds you? Are there any shades, of the same person there?
I don't think that's an assessment that I could really make. I mean, I've never met Miss Vallow,
Yeah.
so that's not really an assessment that I could make.
Yeah. Um, in watching her opening statement, I mean, did it exceed your expectations? Was it about what you expected? I mean, what were your thoughts on it, if anything?
Well, I've seen people that represent themselves do a heck of a lot worse. And
Mm.
I had very low expectations of what was going to come out simply because, in these cases, sometimes defendants will put forward a lot of irrelevant information. They will put forward objectionable materials. They will make arguments in the course of their opening statement, what have you. And as monotonous as it might be, it appears she did it, certainly wrote and just saying, the evidence will show, the evidence will show. But if she talked to her advisory council or whoever she was consulting with, she picked up on that as a kind of force of what an opening statement is supposed to be. So in that regard, she exceeded my expectations because there wasn't as much objectionable material in there as good as I would have expected. And quite frankly, I thought that if she had her own agenda, perhaps to preach a religious beliefs or things of that nature, we didn't really see any of that in her opening statement.
Yeah, she totally stayed away from that 100%. She doesn't want to, I don't think she wants to go there, but the prosecution definitely is going there because it's in the text messages that they want to present. She kind of laid out what she says the evidence will show. I mean, she used that phrase a lot.
Yeah.
I want to play a little clip of what Lori said the evidence is going to show. This is what she told the jury as far as what happened that day. The prosecutor on the case, Trina Kay, basically told the jury they lured, this was the plan, and they lured Charles Vallow there. They knew he was coming, and they took action. They set this whole thing in motion. It was a staged murder, but Lori says, no, 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 that is not what happened. So I want to play what she had to say, and then I just want to get your reaction to it afterward.
The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will show that Charles' screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother, from her stepfather, Charles Vallow. The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground, and Charles lifted up the bat to hit Tylee with the bat. The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. He did not have a gun. He was not wearing a shirt. He was pulling up his jeans because he just woke up and came into the room where he heard the screaming. The evidence will show that Alex and Charles got into a physical struggle for the bat and fell onto the ground. The evidence will show that Tylee, who was on the ground, was lifted up by me and sent outside to get away from the struggle and to protect JJ, who was still in the running car, in the rental car in the driveway. The evidence will show that after the struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun. The evidence will show that I ran outside to the children and that Alex shot Charles in self-defense.
Okay, so that was a little more quiet than I had planned it to be. It didn't play as loudly, but I hope you could hear all that. So she gets kind of choked up and she's explaining what happened that day. Was she effective? I mean, opening statements are not evidence, of course, but Kirk, did you think she was effective there? She's getting choked up talking about recalling this traumatic event that happened back in 2019.
I don't think so, but I think one of the things that I focused on when I heard those words for the first time yesterday was the idea. Well, two things. She did two things, I think, in that clip. One, is made it very obvious that the evidence that she's talking about, it has to be her own testimony. No one else is around. Obviously, her children aren't around. And so she is going to be the one that has to testify to this supposed abuse that she's trying to pin towards Charles, right? The other issue now, as you said, opening statements isn't evidence, but what this might foretell is the idea that she will open the door, if she hasn't already, because she said it in opening statements, towards the situation in Idaho, the killing of her children, moving into evidence. Because if she's going to talk about this purported abuse, etc., and some of the things that happen, that brings up the specter of her involvement in the death of her own children. So it was ineffective in that regard. Whether the jury caught on to all of it or not, we don't know. But if she takes the stand, as her opening statement foretells, she's going to be in a world of hurt in terms of entering that evidence into this trial.
Yeah, I feel like game over. If Tylee and JJ's deaths come into this trial, and the fact that she's been convicted of being a part of their murders, she's done. So it's going to be hard enough, it sounds like, with some of the evidence that the state has. But once they hear that, it's over for her. And she does want to testify. She's basically said that she's going to testify. So she's going to have to be really convincing, and maybe convince one juror if that evidence comes in. If the judge says, yeah, you brought up your kids, you opened the door, tough luck. I mean, she's done.
No, I agree. I mean, look, I don't like her prospects at all. I mean, as I said I did some discussion about this case before going into it. Her best defense is, because she's being charged with conspiracy to commit murder, is to demonstrate that the killing of Charles Vallow by her brother was not a murder. But she's not doing that, right? She is turning it into some kind of tale of abuse that doesn't seem to have any foundation in fact, other than her word. Now, that could happen sometimes in domestic violence cases, but she doesn't have any expert testimony to back it up, etc. So you do expect her, and whether she's a narcissist, we can all play amateur psychologist, but she's going to get up there under the guise that she is going to convince one juror, and I think that's going to fail. And let's keep in mind, Anjanette, one thing that is different in Arizona as opposed to a lot of states, I know there's a few states that do it, jurors will be able to ask questions of Ms. Vallow if she takes the stand. And as long as they're not objectionable questions, meaning legally objectionable questions, those questions will be asked. And one of the things I think we're going to see, and when we talk about questions like that and some of the evidence we're seeing come forward today that I thought was objectionable, Ms. Vallow doesn't know when to object. So there's going to be a lot of harsh questions from the jury coming her way when or if she takes a stand. And you're right, she said she's going to. Doesn't mean she has to follow through. She can always back out. But, if many are correct of her enjoying her time in the spotlight, as it were, she's going to take that stand, and she's going to relish in every minute. And let's face it, she's got nothing to lose. She's serving life in Idaho. That conviction's not going to be overturned, and she's likely to be convicted in this trial as well.
Yeah, it's I feel like she wants to tell her story once and for all. She didn't take the stand in Idaho, and I don't know. I mean, she wasn't facing the death penalty in Idaho. She was at one time, and then the judge threw it out. He struck it because the prosecutors didn't turn over some of the discovery. So she could have rolled the dice and taken the stand in that case. But she didn't. So I'm sure her lawyers were telling her, no, don't do it. So we'll stay tuned to that one. I want to pivot now to the Kohberger case. Bryan Kohberger is going to be back in court on Wednesday in Boise. They have a bunch of stuff. They're arguing over tons and tons and tons of stuff. His lawyers want to keep out basically everything, but they lost all their motions to suppress. But one of the things they want to keep out is his Amazon click history, which shows apparently him purchasing a knife sheath and K-bar knife in March of 2022, like 8 months before the homicides. His attorneys say that's not reliable. It can be influenced by AI. The state says whatever. He bought the knife. He bought the K-bar. We have witnesses who will testify to it. What do you think about that, Kirk? That's got to be a really challenging piece of evidence for the defense, since they found a sheath with, his DNA. Obviously, this will all be tested in court. It will be subject to cross-examination. But right now, the state's saying his DNA is on the inside of that snap of that knife sheath. So that's a tough one.
Yeah, but keep in mind, Anjanette, I mean, when we have a death penalty case, guilt of the accused is almost presumed, right? And the real ultimate goal of the attorneys for somebody who's accused of the death penalty is to save their client's life. So when we talk about all these motions and the history and the issue of Mr. Kohberger possibly being autistic, all these are designed for an appellate court down the road. The judge in this case is probably going to, deny every single motion, but he is going to be the first word, not the last word. A death sentence goes up to the United States Supreme Court automatically. There are years of review. A capital defense attorney has to account for what possibly could change in the law 10, 15 years down the road. They have to be a bit of a fortune teller, if you will, and make reasonable arguments of laws that could possibly change so they can preserve that record. And that's what these motions are really about. That's why we've seen them attack the viability of the warrantless DNA search of the snap that you're talking about, and some of the other motions they are making. It is for that reason, for that appellate record down the road.
So you think, because it is a capital case, his attorneys basically realize, because they're saying, Bryan Kohberger, the guy in this photo, and there's been a lot said about this selfie. We'll hear what the state the defense has to say about it at trial. But they're saying he is hopeful to be exonerated and he's innocent, and that, they're his lawyers. That's their job. But you're saying basically they're playing the long game. And, we've heard Ann Taylor say many times in court, I have to make a record, Your Honor. Whenever he's trying to move things along, she said, I have to make a record. You think this is all about the long game, and they believe potentially, and I'm not asking you to speak for them, but you've been in their shoes, that he'll likely be convicted, and they're playing to save his life.
Yeah, I mean, that, ethically speaking, and all other, issues aside, their ultimate goal is to save their client's life. If they feel like, obviously, contesting certain bits of evidence, asserting his innocence out into the public domain, given the court of public opinion, what they feel now, things of that nature, because it's all designed to save his life. And when we talk about, Anjanette, there's that proof beyond a reasonable doubt, but there's something in capital defense work, it's kind of called residual doubt. And we see that come up with other points of DNA. The fact that the only DNA of Mr. Kohberger was on this snap. Mm-hmm. And it becomes a question of, for those jurors, because the same jurors that hear the guilt or innocence phase preside over the sentencing phase. And it's not a matter of whether it's reasonable doubt. Do they feel certain enough? Because that's a different level of certitude. They feel certain enough that Mr. Kohberger committed the crime to sentence him to death. And so you could see maybe they're going to try to assert his innocence, make their claims to try to kind of lay the foundation for that possible doubt in somebody's mind. Because while a lot of people watching this might think, hey, I could convict him, I could sentence him to death. Jurors that are death penalty qualified have to be able to give both sentences after finding someone guilty of a heinous first-degree murder, a heinous first-degree murder of 4 individuals in this case. They have to be open to that in order to be constitutionally qualified to do it. And that takes on a whole new light when you're in a courtroom with someone, in this case, Bryan Kohberger, for several weeks. You may see his family there. You're being asked to kill someone's son, right? So it takes on a whole new dimension than you and I just talking about it. And it does take, I think, for many people, an extra level of certitude.
Yeah, I think it would be a really heavy, thing to consider. I was a juror on a murder trial a long time ago, and it was nothing like this. I mean, not even close. And just deciding that I felt like was a huge responsibility. And it was pretty compelling. So I can't imagine sitting on a case like this and then, making that decision. I mean, you would have to, it's a big deal. It's a big deal.
Yeah, there's no doubt about it. And like I say, one of the most common things I hear from people when you're doing a voir dire in a death penalty case, and I should add that process, because you weed people who are absolutely against the death penalty out of it, going back to what we talked about earlier, those juries that are death penalty qualified are also more likely to convict. So that adds to the point I'm making earlier, right, about the likelihood of conviction. But going back to the sentencing, the thing you hear most often is that, they are conflicted, and they have to sit there and say, I would ask you as a juror, say, Anjanette, if you were to find that Mr. Kohberger was guilty of killing these 4 college students, could you still then sit and give meaningful consideration to the mitigating factors that we're going to present during the sentencing phase? And a lot of people might say, no, if I find that he killed all these 4 people, I am straight to the gas chamber. And that person, or firing squad in this case, that person would be let go of jury service. They'd have to say, I will give meaningful consideration to autism or IQ or whatever mitigating factors that they ultimately decide to present to the jury. So that's, part of what we're seeing here with all these motions, that part of what the overall strategy is in saving someone's life.
I want to talk about the whole autism thing, because that's the defense's latest effort to strike the death penalty. They say Bryan Kohberger has autism, and he's got this diagnosis, and it's the highest functioning level of it. The state says, well, your own expert says he has an IQ of 191 and he's socially awkward and stuff like that. And so he doesn't meet the whole criteria for Atkins, which means you would have an IQ of less 70 or below, and a hearing is required, things of that nature. Judge Hippler has already said, he's told the defense, apparently, in the state, the defense wrote this at the end of a motion. They're hopping mad about it. Judge Hippler said, I'm not having an Atkins hearing. So they are being given 15 minutes to argue their motion to strike the death penalty, saying that he has autism. He has this diagnosis, and that he's also got obsessive compulsive disorder and this developmental disorder. So, the judge isn't even giving them the Atkins hearing. So, what do you think about that?
Well, again, that goes back to laying the foundation for the appellate record 15 years down the road. Because right now, the current state of the case law in the United States is you can't execute a person who's mentally infirm. They have to understand the reasons for their execution, etc. Now, autism isn't a de facto bar to execution in that regard. But say, hey, listen, and the judge not giving them a hearing makes it all the more powerful, because then they say, listen, here he is 10, 15 years down the road. The autism's gotten worse, and he's not competent to be executed. And 15 years ago, when we tried to put this in front of the judge in Idaho, he totally rejected the motion and wouldn't even allow us to hear it. So you, appellate court, should allow us to litigate that at a hearing with a current assessment of Mr. Kohberger's mental health. That's really what this motion does. Like I say, this judge is the first word, by far not the last. And that's what they're going for, the long game, as you've called it.
Yeah, I'm wondering if they, it's like if I were Judge Hippler, and I've never been a judge, I've just watched a lot of them. You don't want it. I'm assuming you don't want to be. I mean, I've always heard judges never want to be overturned, or they're like, okay, fine, kick, whatever. If I make a mistake, I've heard other judges kind of act like, if I make a mistake, the appeals court will, take care of it or whatever, which I'm just like, wouldn't you just want to do a good job? But I don't know. Should he just have the Atkins hearing, the evidentiary hearing, and let them present their evidence?
I think so. I mean, they deserve the right to make the record on this stuff for that appellate record. And his denial of it is only exacerbates the situation, I guess, when you go down the road, because he should be concerned, because, this is an ordeal that, doesn't end with him declaring a death sentence upon Mr. Kohberger. It's the 15 years, the appellate record, all those sort of things. And it could very well come back and put the families through extra angst. That's why everybody doing a death penalty case should be at their sharpest and should be presenting everything they possibly can. And the defense doing this is really a service to the court and justice. If they were laissez-faire, they didn't do a lot of work, there's more of a chance that a death sentence would be overturned. Because last time I remember, I've been out of the game for a while, but about 50% of death penalty sentencings, not the verdicts, not the guilty verdicts, but the sentencing decision for death, are overturned based on either a judge's error and or the ineffective nature of the defense counsel at the mitigation phase.
Oh, interesting. Yeah, I would, if I were the state, I'd be like, because they don't want a hearing. I mean, the judge literally says, apparently is giving them 15 minutes to argue their motion, no evidentiary hearing. Gosh, if you're the state, why don't you just say, okay, fine, have an evidentiary hearing. Call your experts, I'll call mine.
Yeah,
and they want to do their own evaluation of Kohberger. You would think they'd be like loving that.
Yeah, I don't understand why not. I mean, I think that would be the sort of process that should be followed in a death penalty case.
Yeah. Well, Kirk, it's been awesome. We'll see how it turns out during this hearing this week. Thank you so much for coming on. It's been great seeing you and talking with you, and we'll keep tabs on this. Everybody like and subscribe, share, and all that good stuff. Again, Kirk, thanks so much.
Thank you, Anjanette. Great talking with you.